Good afternoon and welcome to the National Juvenile Defender Center webinar on strategies to advocate against the pretrial detention of youth. I'm Marianne Scali with the National Juvenile Defender Center, and I'm joined by my colleague, our Gault Fellow, Aneesa Khan. Thank you so much for taking time to work on strategies to prevent and eliminate the pretrial detention of young people in the juvenile Gault system. We're also really grateful to our partners at Arnold Ventures National Partnership for Pretrial Justice and the Aneesa Khan Foundation Juvenile Justice Strategy Group. Our partners have supported work that allowed us to produce two new resources that we just released that we want to talk about today as we really brainstorm with you about ways we can enhance our arguments to ensure that courts make decisions that decrease the number of young people who are being sent to facilities. So one of the resources that we were able to release is called A Right to Liberty. This is a national snapshot on the use of juvenile cash bail throughout the country. The second resource we're going to be talking about today is a juvenile defender checklist that looks at facilities. We're going to be walking through this today to talk about how we can really be tracking information in places that are housing young people that are sent through our court system today. In the webinar, we're going to really go through a few things and wanted just to give you an outline of the discussion today. So first, we're going to talk about the risks associated with youth incarceration. Second, we're going to explore the legal mechanisms that allow courts to send young people into facilities. And third, we're going to focus on the challenges that young people in juvenile courts face as they are in juvenile courts and in facilities. And really talk about how these resources we developed can be used to enhance what we're doing to advocate against detention and incarceration of young people. All right, so we're going to start talking about the risks associated with incarcerating young people. So oftentimes when we are in court or we're advocating on behalf of young people, the dialogue that occurs when we talk about risks is often risk to public safety, or risk of harm to others, even risks to the community. And we don't often hear the conversation really focused on the risks to young people themselves when we decide as court systems to incarcerate young people or to detain them in pretrial facilities. So we want to really be thinking about, as we advocate with prosecutors, probation officers, and judges, what are the risks associated with incarceration and what risks do young people themselves face when courts decide that young people should be incarcerated? So first, we're going to start by talking about the risk of victimization. What do we mean by the risk of victimization? So youth in facilities are at a higher risk for victimization in courts. Just to note, when we're talking about victimization, whether it's in detention or incarceration, we are using those words interchangeably today, since detention is one form of incarceration. And also, a number of the studies that we're talking about in the webinar today included youth in both pretrial detention and commitment in correctional facilities. For purposes of today, we're really focused on the advocacy against pretrial detention of youth, but just to know, we may be talking and using the words detention and incarceration interchangeably. Okay, so risk of victimization. According to findings from the Survey of Youth in Residential Placement, 29% of young people in custody reported that they were beaten up or threatened with being beaten up by other residents or facility staff. This Survey of Youth in Residential Placement was the largest study of youth in custody, and it's based on interviews with a nationally representative sample of young people in custody during the spring of 2003. Facilities in that study were both pre- and post-adjudication facilities, and so this is both detention and commitment facilities. Other key findings from this study were that 10% of young people in custody said that during their time in the current facility they were placed in at the time of the study, someone used force or threatened to use force against them. Another finding in this study was that 46% of young people who are in facilities said that their personal property was stolen when they weren't present while they were in facilities. So when we think about risk of victimization and what happens to young people when we decide that they should be removed from their communities and placed, is that they are at heightened risk for victimization for assault, robbery, or theft. Another element of victimization that we don't often hear considered as courts are really contemplating whether or not to release a young person is the fact that when young people are sent to facilities, there is an increased risk for sexual victimization. So we know that the Bureau of Justice Statistics did a large national study called The Sexual Victimization in Juvenile Facilities, reported by youth. And in this report, they found that youth in facilities, 9.5% of them reported experiencing one or more incidents of sexual victimization while they were incarcerated. So this, I think, is an important piece for us to be thinking about as we're talking with decision makers about incarceration or pretrial detention of young people, that 1 in 10 youth are describing facing sexual victimization while they're in facilities. And we also know, and you've seen it reported, that numerous states have ongoing lawsuits alleging physical and sexual abuse. You may have heard recently about the Glen Mills facility, a facility in Wisconsin, and historically we've heard about facilities in Florida, California, and Texas, all facing lawsuits because of the victimization that young people have experienced while being placed in those facilities. So victimization is a great concern. We also know that while young people are incarcerated, their experience of being there places them at heightened risk for recidivism. So there's 3 key studies that we're going to talk about and look at, and we encourage you to look at and use in your advocacy against pretrial detention. One is a piece of work conducted by Deshawn and his colleagues. Talks about how when young people are actually confined together and they're confined based on undesirable behaviors, even in positive intervention settings, that it can have the unintended negative consequence of increasing undesirable behaviors. So Deshawn and his team conducted several studies exploring why this happened, and their findings have really important implications for us in the juvenile court system as we advocate against pretrial detention of youth. And most importantly, we note that they found that incarcerating young people can actually do more harm than good. A second study was Gotti and his team. They looked at a longitudinal study of youth being placed in facilities and found that young people who face more restrictive interventions, meaning that they're in residential facilities versus in the community, are more likely to be arrested as adults. So again, recidivism rates go up when we lock up young people in secure facilities. Finally, Logren and his team of researchers conducted the Pathways to Desistance study. So this is a significant longitudinal study that was conducted looking at long-term effects of incarcerating young people who were charged with felony offenses. Researchers found that recidivism rates were the same for youth who spent longer periods of time in residential facilities as youth who spent time on probation. So meaning that although we're spending so much more money when we lock up youth, pretrial and post-disposition, that we're not actually seeing any long-term benefits to youth. We're not seeing benefits in terms of youth success, and we're certainly seeing more taxpayer dollars being put into incarcerating young people than providing services for them in their communities at home. All right, so risk of victimization and risk of recidivism are important considerations as we're advocating against the pretrial detention of young people. What else do we need to be concerned about? Of course, we also see in the research that when we incarcerate youth or detain them pretrial, that we increase their risk for dropping out of high school. We all know that education is a protective factor, and that when young people are succeeding in educational settings, that it's less likely that they're going to come back into the courts. Well, research suggests that when the juvenile courts increase detention of young people, that we decrease the likelihood that they're going to graduate. So we actually are derailing young people's education when we put them in facilities. We disrupt their progress through the educational system, and this has actually long-term negative outcomes for them in terms of educational success and workforce outcomes. So youth who are incarcerated are less likely to graduate, which we know is connected to impacting their long-term ability to make successful transitions to the workforce and back to their communities. So we've looked at victimization, we've looked at recidivism, we've looked at educational outcomes, all with negative impacts to young people. So finally, let's look at the long-term physical and mental health issues associated with incarcerating young people. This is a newer study, and it was a national longitudinal study of looking at adolescent health as compared to adult health. And it looked at the relationship between cumulative incarceration and the impacts it had on young people in their adulthood. And what we find is that there are impacts in 3 areas: general health, functional limitations, and depressive symptoms, including suicidal thoughts. So adults who experienced incarceration for less than a month. So these are adults who, while they were young, experienced incarceration for less than a month. They were still more likely to have depressive symptoms than adults who had not been incarcerated. When we looked at adults who were incarcerated for periods of 1 month to a year, they were still more likely to have worse general health outcomes, meaning they get sick more frequently than young people or than adults who had not been incarcerated as young people. And finally, for adults who experienced cumulative incarceration of more than a year, they were more likely to have adult functional limitations, meaning physical limitations like things as simple as walking up a set of stairs and general physical movements. So when we look at this in whole, and we consider the risks that young people face when they're detained or incarcerated, we hope that our communities and our decision makers recognize that we're placing our young people at significant risk for harm associated with detention and incarceration. So we want to consider all of these risks for victimization, worse educational outcomes, physical and mental health problems, and recidivism when we're trying to advocate against pretrial detention of youth. So the next piece we want to talk about in our webinar is, what are the mechanisms that actually allow young people to be detained? So what are the laws and rules that courts rely on to locking people up? And I'm going to turn it over to Aneesa.
Thank you, Marianne. So one of the ways in which your clients could end up in detention is through the detention statutes themselves, if the court finds it appropriate to detain your client prior to adjudication. These statutes are complicated and they require both objective and subjective consideration by the courts, one of which is whether the young person presents a risk to the community or themselves. But like Marianne mentioned earlier, the courts rarely, if ever, consider whether that young person is at risk while in detention centers. The court must also consider whether there are options for conditional release, which could address some of the court's concerns and issues and ensure your client's appearance for trial. One form of conditional release is bail. Bail is a mechanism for ensuring a right to liberty. It provides for release and it preserves a presumption of innocence prior to conviction. It allows the accused to assist in their defense through the identification of witnesses and evidence and through unhampered access to counsel. At common law, bail was a surety, so it was a pledge or an assurance to return to court, and it was not necessarily financial in nature. For instance, the release of your client on their own recognizance with the promise to return to court on the aforementioned date under certain restrictions, such as attending school, requiring alcohol or drug screening or testing, abiding by a curfew in which they must be home by a certain time. That was enough to alleviate the court of any concerns and to ensure that a person both returned to court later, and it was often accepted by the court as a form of bail. Today, cash bail is a more common form of conditional release to ensure a person's presence in court, but when that bail amount is set at a figure too high for both the client and their family to pay, it's deemed excessive under the 8th Amendment. So the National Juvenile Defender Center wanted to understand what bail practices looked like across the country. So we conducted a study to understand those practices and the impact that they had on clients and their families. What we found is that 19 states and territories in the United States have statutes on the books that expressly allow for children facing charges in delinquency court to be released from detention on bail. These states are identified on the map before you by the dark blue color. In speaking with juvenile defenders from those states and jurisdictions, we've learned that courts regularly impose unaffordable bail on children, even in states where the court is required to consider the financial ability of the youth and their families. Children who are unable to afford the bail imposed and are ultimately detained, it exposes them to the same risk associated with incarceration as those on detention status. So Marianne, we've discussed the risk associated with incarceration and the ways in which our clients could be detained. What are some of the challenges that our clients face or struggle with, and how can we as juvenile defenders advocate for our clients' release from detention?
So we hope that everyone who's advocating against pretrial detention of youth is also aware of the high prevalence rates of certain issues among young people who are in juvenile courts. So it's clear from numerous research studies that rates of mental health disorders, trauma, and exposure to violence and child maltreatment of young people in the juvenile court system is far higher than young people in the general population. So, and this has serious implications for pretrial detention and for our advocacy against pretrial detention of young people. We know that the conditions of confinement and the conditions that we see in facilities have the potential to exacerbate symptoms of mental health disorders and PTSD by either triggering young people or re-traumatizing them. And this essentially means that the risks associated with incarceration are magnified and compounded by mental health, trauma, or child maltreatment histories. So let's just look at a little bit of the data about what we know about young people who are in the juvenile court system. So we know that they face higher rates of mental health disorders, that nearly 60% of boys and more than 60% of girls have met the diagnostic criteria for one or more psychiatric disorders. We also know that young people who are in the juvenile court system have experienced high rates of trauma. One study indicates that more than 90% of young people have experienced at least one episode of trauma, and that 84% have experienced complex trauma, meaning they have experienced one and more episode trauma, and that 11% of young people have experienced post-traumatic stress disorder. So they have high rates of mental health disorders, higher experience of trauma, and also higher exposure to violence and child maltreatment. And there are a couple of studies that look at the correlation between exposure to violence and then experiences of being in the delinquency system, as well as a study on the prevalence of abuse in a incarcerated sample of youth that showed that they were experienced abuse at much higher rates than young people in the general population. And finally, there's also educational implications. We know that young people who are in the juvenile court system are generally have greater instances of qualifying for special education services. So the studies say that anywhere between 33 and 45% of incarcerated youth qualify for special education services. And we actually expect that that rate is even higher. So this is just young people who've been identified as qualifying. But as you know, in your work with young people who are in the juvenile court system, many times young people come in who have unidentified special education needs. And we in our advocacy have to make sure that when young people qualify for special education needs or could be qualified for special education services, that we also advocate for meeting those special education services within the system. So these higher prevalence rates of things like trauma, mental health disorders, and exposure to violence, as well as special education needs, again, give us additional reasons to be advocating against pretrial detention of youth. So what we want to talk about next is really looking at these risks associated with incarcerating young people, meaning risks to young people, these higher prevalence rates of issues that we know that our population of youth in the juvenile court system experience, and then look at that in connection with what's happening in these facilities and what do we know about these facilities. So we're going to now turn to our juvenile defenders facility checklist. And we're going to talk about the things that all of us as advocates should learn about the places where young people are being sent and being sent by the state and by courts. So we're going to talk about the juvenile facilities checklist, walk through a range of the issues that have been identified in these facilities, and ensure that we in our advocacy work together to learn about what's happening in facilities, use this information to educate courts, and ensure that we are decreasing the number of young people who are being held in these pretrial facilities. So I'm going to turn back to Aneesa to start talking with us about our juvenile facility checklist.
So we at NJDC have developed a checklist for defenders to help in their advocacy, to think more broadly about these issues and help defenders formulate individual strategies for their advocacy in releasing clients from pretrial detention. The tool was designed to assist juvenile defenders in assessing the safety of the juvenile facilities where their clients could be housed and their clients' risk of exposure to harmful conditions within the facility and abuse. The categories of questions contained within this checklist were designed to aid defenders in learning about the facilities so that they can use the data and information collected in their advocacy. So as you can see on the screen, we categorize it, we break down the information in certain categories that you can find that information by the page number. And we're gonna skip ahead to learn a little bit more about the physical designs of facilities. We're going to discuss in more detail how the checklist could be helpful in monitoring facilities and where your clients are held. And we wanna explicitly note that though the checklist was intended for both pretrial detention and commitment facilities, for today's conversation, we're gonna focus primarily on pretrial detention issues. So the physical design of the facility is important to note because it helps defenders assess the settings level of restrictiveness within the facility. So what was the purpose of your facility? Was it for punitive and focused on custody and control, such as adult prisons, or was the purpose more focused on positive developmental outcomes, which is what we would hope juvenile facilities to be focused on? We list this category of questions in a way that compares it to adult facilities for the purpose of assessing what that level of restrictiveness is. So for instance, does the facility have locked room cells or units? Does the facility have isolation or segregation cells? These types of questions are important for our clients considering how vulnerable they are and the prevalence rates of high trauma levels that they experience, because what we've learned is restrictive settings could exacerbate some of those exposures to trauma, and being held in isolation or segregation cells has a tendency to hinder rehabilitation practices and can also exacerbate that trauma.
Yeah, and so even though we built this facility checklist for defenders, we also want to note that anybody and all of you who are watching this webinar, we hope that you're using this information to advocate against the pretrial detention of young people, and that this particular issue of what the physical layout of the facility is so important to bring in front of the court. We know that a lot of decision makers and even some advocates haven't visited juvenile facilities. We encourage you to do that, and to bring information, even photographs about what's happening in those facilities before decision makers. We were really recently in a jurisdiction where I talked to a couple of people about isolation and segregation, and a couple of the advocates said, oh, that doesn't happen where we are. And the third advocate piped right in and said, oh no, I just had a young person who said because they said something not nice about one of the guards, for 4 days was locked by themselves for 23 hours a day. So what is the facility's process and policy regarding segregation and isolation? What do those facilities look like? What are the rooms like? And recognizing, again, as we look on the other side of the screen, how those practices really heighten the risk for victimization and trauma in the lives of our young people, and really worsen their long-term outcomes. So just noting this physical design and really asking ourselves these questions, working with our colleagues to track what's happening in facilities, if they're changing what the facility physical structure looks like, and making sure that we're bringing that information before the court is essential in ensuring that we're doing the most that we can in terms of our advocacy against the use of these facilities with our young people.
And so the second section is on family contact. What we know about adolescent development is when youth are engaged with their families, with their community, those families become emotional support, and it's important for their development to maintain that communication and those support systems. Youth who are involved in the in the juvenile justice system have complex family dynamics, and it's important to them that they remain engaged with their family to help work on those challenges and help promote positive development. So we want to know, are youth able to have full contact visits with their families? Are they allowed to hug them, touch them, hold them? Are there limitations to those visits? Are there limitations on who can visit? Is it restricted to just their parents or legal guardians? Can they stay in contact with their siblings or grandparents or even their friends? Whoever offers a positive support to this individual, do they have contact with those people? Are there any limitations of how often they can visit, or whether or not there's any if they're strip searched after those visits? That's important to note, especially given the high level of prevalence for youth who have been exposed to sexual victimization.
So we know that strong adult and family relationships are one of the critical protective factors for young people, all young people. And that for young people who have experience in the juvenile court system, ensuring that they've got those strengthened family and community relationships is essential. And understanding what kind of contact they can have and how frequently they can have it is important. It's also really important to recognize where those facilities are located and how far they are away from young people. And is there transportation for families and loved ones to get to visit their young people while they're in these facilities? And again, ensuring that we as the advocacy community are letting decision makers know what the limits are, what the barriers are, and how important it is that we do whatever we can to support and allow young people to be in environments where they can maintain those critical relationships. So we talked a little bit about the risks associated with cutting young people off from their education, and how critical it is that we do whatever we can to ensure that young people are able to maintain and continue on with their educational success. So one of the things we want to be looking at when we're visiting facilities and talking with young people about their experience in facilities is really trying to understand the educational programming and other programming that might be available to youth in these facilities. What we know is that it varies greatly from facility to facility, and that it's critical for us to understand specifically at the facility a court might be contemplating for our young person, how much education is provided on a daily basis, how many hours of education. Is that education individualized? Are there special education services even provided at that facility? Does the facility get access to our young people's IEP records if they have them? Does the facility have trained special education teachers? Are the special education teachers certified in special education? And can they really meet the educational needs of young people who are placed in those facilities? Essential for us to ensure that all decision makers recognize how derailing it is, how harmful it is to cut young people off from successful education programs, and really do more to ensure that young people are connected to community-based educational programs that can meet their individual educational needs and goals, and ensure that our advocacy helps decision makers recognize that they can make better decisions on behalf of young people by looking at the limits of what's available, especially in detention facilities, and the opportunities that could be available in the community-based settings.
So another thing to note is the use of forced solitary confinement and restraints. We know, given the prevalence of youth and their exposure to trauma, this risk of victimization, that these are all important categories to note. What are the facility's guidelines on how much force can be used? And more importantly, does the facility practice those guidelines? Is it consistent with what they're required to do? Does the facility keep data, aggregate data, or records on the use of force or disciplinary actions? Can you or the public access that information? Is that limited through access? Are there any documented instances of inappropriate or unsafe application of force? Under the facility's policy, when can a youth be placed in room confinement? Are their practices consistent with those guidelines? Are there other names that they use for isolation that perhaps if they have a separate segregation unit, but they're instead isolating young people in their own individual cells to the same isolation restrictions or administrative policies where they get regular checks, where an administrator has to be involved, are those actually being followed? What are those conditions of room confinement? Are things removed from their room? What can they keep in their room? Does the facility use any mechanical restraints, any chemical restraints? How often, for what purposes? Are youth subjected to strip searches? All of these levels of restriction have a tendency to expose the young person to more risk of victimization. And not only when it's used against the young person, but does a young person, are they familiar with how often these things are used, and whether or not they're in fear? Just fear alone could be a form of risk of victimization.
Yeah, and again, I think especially with mechanical restraint practices, strip search practices, isolation practices, we all know the harms that these practices really achieve, and the long-term outcomes for young people who face these really abusive practices in facilities. And I think as our courts are considering the risks to public safety, they have to be thinking about the risks of what we're doing to our young people as we use things like mechanical restraints and wrap restraints and strip searching. In our advocacy, we don't think many decision makers are aware of the frequency of strip searching, the frequency of using mechanical restraints on young people, the frequency of even shackling practices as they transport youth from a facility to the court system. We think if we could raise awareness about these harmful practices and really physical abuses that are occurring to young people in courts, that courts would make different decisions about who they detain and the frequency of using detention as an option, rather than looking at community-based, developmentally appropriate practices. But it's really important for us to understand the policies, what's allowed, how frequently those procedures are used, and even when they are they followed in a way that complies with what the policies say they should be doing? But just noting again how when we look at these practices in line with what's developmentally appropriate and what helps young people succeed, we know that all of these practices really counter what is best for young people and doesn't give them an opportunity for success. So we're not talking about all of the categories of questions. You can see here we're scrolling by disciplinary procedures and grievance procedures, and we're really focusing on just a few for today. Just to direct you to the facility checklist, we want to note that it's available on our website at www.njdc.info, where you'll also find our page on bail. So another category of issues that we really want to be sure all advocacy groups and individuals are looking at are abuses, physical or sexual abuses, violence, and neglect that occur in facilities. It's clear by the number of lawsuits that have been brought against states, counties, jurisdictions, and facilities themselves that despite the fact that most people in the community don't think that young people are harmed at the hands of the state, that in fact they are. So things that are really important to know: does the facility have any reported or documented instances of abuse, physical and or sexual? Again, we'll refer you to the recent case in Glens Mills. Our colleagues at Juvenile Law Center filed litigation against them. But we know that 2 decades ago, young people were facing abuse at Glen Mills. And how does this keep occurring? Are we as advocates staying on top of and asking our young people what's happening to them while they're at facilities? And are we ensuring that the courts are aware of and know what's happening? Does the facility itself keep data on physical or sexual abuse? And if they don't keep that data, does whoever responsible for the facility keep that data? Is there data on violence or neglect of young people in facilities? And does the facility develop and implement policies that comply with and enforce the Prison Rape Elimination Act? Really making sure that we track down this information. We do public records requests that Aneesa is going to talk a little bit more about in a few minutes, and doing everything we can to collect the data that's out there, but ourselves across the advocacy community in our jurisdictions, noting that when we find out about abuses, be they physical or sexual abuses, that we're letting our colleagues know, we're sharing that information with our advocates so they can be on the lookout and ensure that other decision makers aren't putting our children in harm's way as they're making decisions about release.
And I'm going to keep scrolling down to youth health, maintenance, and safety. So do youth have access to medical health, and dental care for emergencies as well as for ongoing treatment? Given the high level of prevalence that our young people face, especially when it comes to mental health, we know that it's important for ongoing care and for initial diagnosis when they're in the detention facility. How quickly after they are placed in a facility are they getting access to the prescription medications that they need? What access do you have for counseling and or mental health care treatment professionals? Are those professionals licensed within the state or whoever is in charge of licensing? Do they receive the immediate health and the ongoing health? These are all things to consider when it comes to the health of our clients and what the lack of care might lead to future risk associated with incarceration.
Right, and we also know that, again, I don't think decision makers are aware that often there's a lapse in medical care and mental health treatment and care when young people are removed from their communities and sent to a facility. I think there's an assumption that the facility is going to manage both mental health and physical health of young people. And what we know is there's often a lapse in care when young people are sent to facilities, and it's critical for us as advocacy communities just to know what the practices are and what our experiences are like, what young people's experiences are like when they actually are sent to those facilities.
And so staffing and staff training is also important. What are the characteristics of the staff? Are they representative of the youth that are being housed? Are they the same race or ethnicity in the facilities? What kind of training do they receive? Are they provided use of force training and training in de-escalation techniques? Are they provided training in trauma-informed care or adolescent development? Are they provided training in cultural diversity, especially if they're not the same race and ethnicity of the young people that are being housed in that facility? What kind of training is provided to them regarding PREA protocols? All of that is important to note, especially for this level or the risk of victimization when they're not properly trained and when inappropriate use of force is used against young clients.
Yeah, and I think also understanding the type of training that staff are receiving at a facility lets us as advocates know a lot about the facility. Our staff receiving a lot more law enforcement type training, a lot more training on hold techniques than they are on developmentally appropriate practices and de-escalation techniques. If the facility is providing staff with a lot more training that looks like law enforcement, it's a lot more likely that young people are experiencing a hostile environment instead of a nurturing environment.
And so we know that this is a lot of information that we're asking defenders to collect, but one of the big things that defenders need to keep in mind is this risk of victimization, and not just, and what harm or what the potential of harm is for incarceration, not just in immediacy, but also for long-term consequences for our client as they transition out of facilities and back into the community. So in collecting this information, we would ask defenders to regularly visit their facilities, to speak to their clients, to speak to former clients who may have been housed in those facilities, to speak to stakeholders who are more knowledgeable about those facilities if they're not able to immediately visit them, to use informal public request and also public request if information is not provided by the facility in an informal way. We also provide resources to organizations and publications that are currently monitoring facilities and how to access more information about those individual facilities. For public records requests, it's important to note that the laws are state specific. So we do include citations to a website that provides information on what the public records law is for your individual jurisdictions. We also include a sample public records request form, so a sample FOIA request where we provide information on the different types of categories of information that you can receive from facilities or from the organizations that are in charge of monitoring or overseeing those facilities. So things related to what the racial and ethnic breakdown is of the youth being housed in your facility, what the total number of crossover youth is, what the number of staff is, what the staff to what the youth ratio is within the facility, what the training requirements are, who are they trained by, what kind of training do they receive prior to working at the facility or ongoing training that they receive. We also include information. We ask that you get a copy of the handbook that youth are provided so that you're aware of what rules or restrictions there are on youth and whether or not facilities are following those guidelines or policies in place, what the non-discrimination practices are, whether or not the facility is following PREA guidelines, and if that information is publicly available to youth and their families.
And again, this is a sample for you, and really all of this is about getting information that we can use in our advocacy. So the facilities checklist provides a really wide range of information that we hope you yourself can gather, or that you can work with your colleagues to ensure that you gather. But this FOIA request is just a great sample of a way to try to begin to collect some of the information about the facilities where young people are housed. And again, just a reminder that you can grab the facilities checklist and the snapshot on bail at the NJDC website at www.njdc.info. And in putting together this webinar, we did receive a couple of questions from advocates about pretrial detention and about strategies to decrease pretrial detention. So we just wanted to respond to those questions in the webinar. So one, a community member asked whether or not we had prepared a brief with these legal arguments and citations in them. So we have not yet done that, but we will work on preparing that and making that available. Similarly, we received a question about whether or not there is a bibliography with all the studies that were included in the webinar discussion. And again, not yet, but we'll work on building a resource. In the meantime, we hope you can use the slides, which are available in the webinar, as well as to those of you who participated in the live webinar, and you can use those citations until this annotated bibliography is available. A final couple of questions. We did receive a question about research classifying youth by race based on concerns of gang involvement. And we do not have research available on that issue, but we'll continue to look for it and suggest that research be done, but understand that is definitely a concern if you're seeing that kind of practice in your facility. And finally, there was a question about the newest study that we cited on depressive indicators and symptoms. And just to note that it came out in the Journal of Pediatrics, and that it's called "How Does Incarcerating Young People Affect Their Adult Health Outcomes?" And if you're looking for that, we hope that you can find that while we're building the brief and the bibliography. Anything else? All right, thank you so much for joining the National Juvenile Defender Center for this webinar on strategies to decrease the pretrial detention of young people. We hope that you have heard about some useful strategies, and please do reach out to us at NJDC if you have additional questions, or if you'd like to work together to decrease the pretrial detention of youth in our juvenile courts. Thank you so much, and thank you for all the work that you do.